Thank you. I'm very grateful to be here. And the reason for the invitation is this book I wrote, Disability and Information Technology. And in the book, I talk about the need to protect the rights of people with disabilities as citizenship rights. And also the need to protect the rights of all people with disability, sensory, dexterity, cognitive disabilities, and to tackle the barriers to accessibility. But I've got a confession to make. When I first started writing the book, I knew that I wanted to write about citizenship, access to information, and disability. But when I was thinking about disability, as I started writing the book about 8 years ago, I was thinking about sensory disability. It never crossed my mind to look at cognitive. And as I started researching, I realized how important it is to look at cognitive disability as well, and the barriers to accessibility encountered by people with cognitive disability. And this became one of the main arguments in the book, the need for protection for the rights of all people with disability. And my mistake of originally overlooking the need to protect people with cognitive disabilities is unfortunately a mistake that is apparent in legislative frameworks across the world, where measures that deal with accessibility to information tend to concentrate on sensory disability. And I mean this with all the respect for sensory disability. But there seems to be a hierarchy of protection for people with disability, with cognitive disability being unfortunately overlooked by a number of provisions. So I think that the declaration presented today does an amazing thing as a benchmark for removing the barriers to accessibility for people with disabilities, with cognitive disabilities, and expressing the right of people with cognitive disabilities to have full and equal access to information and technology. So, thank you. Information and communication technologies play a very important part in everyday life, but unfortunately, people encounter a range of barriers to access. And in this paper, I plan to do three things. Firstly, I would like to talk about a framework of principles that should guide regulatory frameworks dealing with access to information. Secondly, I want to look at some of the common challenges encountered by jurisdictions, by the jurisdictions in my case studies. And I want to look at the CRPD, the Convention on the Rights of Persons with Disability, and the declaration presented today as benchmarks to address these challenges. So I'll start with a framework of principles. And I'm calling for a regulatory framework that protects the citizenship rights of people with disability, that relies on an active regulatory intervention to eliminate accessibility barriers, is focused on tackling social barriers, prioritizes citizenship interests, promotes universal designs, and involves people with disabilities in policy making. So first of all, a regulatory framework that protects the citizenship rights of people with disabilities. And access to ICTs is a crucial part for participation in civil society. It's often a prerequisite for participation in employment, education, social life, political life, and so on. And it's very important that regulatory frameworks perceive people with disabilities as more than just consumers or users or economic actors, that people are perceived as citizens And there is a difference between the concept of consumer and the concept of citizen, because the notion of consumer is a very narrow concept. It refers to people pursuing their individual interests, and the focus tends to be on lower prices, increased choice, increased quality. Whereas when we talk about citizens, the focus is much wider. The focus is on wider social values, and we act as social actors. And the emphasis tends to be on wider values such as equality and participation in society and respect for difference. And it's very important that measures actively pursue equality. Now, when we talk about formal equality, the emphasis tends to be on making sure that nobody is disadvantaged because of perceived differences. But the key argument should be for pursuing substantive equality, actively removing barriers to participation, and engaging all key stakeholders in the removal of those barriers, be it market players, policymakers, regulators, people with disabilities, organizations representing people with disabilities, and the civil society in general. So we need a proactive approach to dismantle barriers. And when I talk about citizenship, I don't mean it in the narrow sense of nationality of a particular country, but in its wider sense of the values associated with this concept. And I know that a number of jurisdictions tend to justify intervention on the basis of the pursuit of the public interest. But the public interest is often not very well defined, and it tends to be hijacked by political and market interests. We need a concept of public interest that is clearly defined and rooted on citizenship values. We need a regulatory framework that's reliant on active regulatory intervention to remove accessibility barriers, because market forces alone cannot ensure accessibility. It's unlikely that market forces alone would protect citizenship rights, because the perception tends to be on people as economic actors, the focus rather than citizens. The focus tends to be on quantifiable issues such as the costs associated with technology, with producing accessible technology, rather than wider, non-quantifiable issues such as the value of having an inclusive society. And the interaction between people and service providers tends to be dependent on people's financial means if everything's left to the market forces. So what we need is an active regulatory intervention to ensure full and equal access to ICTs for everyone, and to address the non-quantifiable issues that are the wider social benefits of accessible ICTs. And perhaps the best way to achieve this is through a complementary application of social regulation alongside economic regulation. We also need a regulatory framework focused on tackling social barriers. So rather than looking at disability from a medical perspective focused on the medical condition of individuals and trying to adapt individuals to society, the focus should be on the social definition of disability, of looking at the barriers that exist in society and adapt society to individuals and to the wide range of abilities that exist. So we need to remove accessibility barriers and address the wider social implications of inaccessible information. And we need a proactive approach in order to do that, in order to ensure social change involving all the key stakeholders, industry players, policymakers, everyone. And that should be driven by wider concerns to protect citizenship values rather than by cost-related considerations. And we also need a regulatory framework that prioritizes the interest of citizens over industry interests. There's quite a great degree of influence by market players over regulators, leading to regulatory capture. So rather than pursuing the public interest, the interest of citizens, we often have the situation where regulators seem more concerned with the private interest of the industry. And that has significant implications for democracy, particularly in terms of participation in society for everyone. So the call is for a regulatory framework driven by concerns to protect citizenship values and based on removing accessibility barriers, ensuring participation and a voice for everyone. And this has wider benefits. So perhaps the way to do that is rather than try to balance citizenship interests with economic concerns, is to prioritize citizenship interests. We need a regulatory framework that promotes universal design because information and communication technologies, ICTs, should be accessible for everyone. And regulatory frameworks should promote the design and development of ICT products and services based on universal design principles, which are defined in the CRPD, the Convention on the Rights of Persons with Disability, as the design of products and services that can be used by everyone without the need of adaptation or specialized design. And the interest of all people, including persons with disabilities, sensory, cognitive, mobility disabilities, should be considered at the outset, at the design stage of developing a product or a service. And that would significantly reduce costs of developing adaptive technologies. And it would have wider social benefits. It would benefit everyone. And it would also send the right message that accessibility is considered at the mainstream rather than as an afterthought. And it's also important that regulatory frameworks involve people with disabilities and their representative organizations in policy making. Because people with disabilities are best placed to identify what are the accessibility barriers and what are the solutions to address these barriers. Because without the involvement of people with disabilities and their representative organizations, measures are adopted based on assumptions of what these needs may be, and maybe based on stereotypical perceptions of disability. And rather than addressing barriers to accessibility, they have the danger to further create barriers. So perhaps some of the measures could be compulsory consultations with people with disability and representative organizations, or involvement of user panels in developing products and services, because otherwise there is already a digital divide between those who can and those who can't access information effectively. So there are a number of challenges, and when I did the book, I looked at this framework of principles, and I looked at 4 jurisdictions and I tried to see to what extent do these 4 jurisdictions, the United Kingdom, the European Union, United States of America, and Canada, to what extent do these jurisdictions protect the rights of people with disability as citizenship rights, and to what extent do they address the rights of all people with disabilities? And I won't go into details as to what the results were for each of the jurisdictions, but I will look at some of the common challenges that were encountered across the case studies. So I'll look at these common challenges, and I'd like to point to the CRPD, the UN Convention on the Rights of Persons with Disabilities, and the declaration presented today as benchmarks to address these challenges. So the first call to address challenges is for an increased protection for the citizenship rights of people with disabilities in the ICT sector, because the access of people with disability to ICT is a citizenship right. Everyone is entitled to have access to information irrespective of their abilities. But what the case studies have shown is that there is an absence of a clearly defined framework of principles in provisions where the rights of people with disabilities are not necessarily pursued as citizenship rights. If I spent many hours looking at the language of legislation to see how are people with disabilities referred to, and there's often reference to people as users, consumers, customers, but not so much as citizens. And often there's reference to people with disability as vulnerable members of society, so very paternalistic language, rather than access as a matter of right, as a matter of a citizenship right. And the public interest concept that is often referred to in legislation as a justification for intervention, it's often not very well defined and is not often rooted on citizenship rights. And that makes this concept subject to misuse by political or private means. And the focus tends to be on people as economic actors. Now, the CRPD promotes the full and equal enjoyment of human rights by people with disability, and that's including access to information. So it's access to information as a matter of right. And it recognizes that access to information enables the exercise of other rights, including participation in public and political life, cultural life, recreation, leisure, and sport. And it highlights not only the importance of ensuring that people with disabilities have access to information, but it also highlights, so not only to ensure that people with disabilities are not missing out on what information and technology has to offer, but it also highlights the importance of ensuring that society in general is not missing out on the pool of talent that people with disability have to offer to society in general, and the important contribution that people with disabilities can make and already make. And the declaration presented today adopts very much a right-based approach. It complements the CRPD by focusing on the rights of people with cognitive disabilities and on access to information and technology. And it adopts a right-based approach referring to the fact that people with cognitive disabilities are entitled to inclusion as a matter of right, and that measures to facilitate access by people with cognitive disabilities to ICTs is a natural consequence of their right to inclusion in society, so accessibility as a matter of right. And the declaration makes the link between access to ICTs and participation in society, and also refers to the strong connection between self-determination and participation, so autonomy and inclusion in society. Accessibility should also be approached through a human rights lens. Now, the case studies have revealed that accessibility is often perceived through an economic lens, driven by cost-related concerns. And even where provisions are put in place to ensure accessibility, they are often subject to hardship defenses. So undue hardship or undue burden or disproportionate burden defenses. So measures need to be put in place provided that they don't impose an undue burden on the market players, for example. But undue hardship defenses are often not very well defined in legislation. And they're often used as a justification for limited accessibility or for the absence of accessibility. Now, the CRPD has the potential to refocus the perception of accessibility from an economic lens through a human rights lens. And it refers to the fact that people with disabilities are entitled to the full and equal enjoyment of all human rights and freedom, including access to information, and calls on state parties to take all appropriate steps for reasonable accommodation. But once again, the CRPD itself refers to these limitations and says that reasonable accommodation should be put in place if it doesn't impose a disproportionate or undue burden. So there's a double limitation here which has been subjected to criticism. It is important to put in place provisions to address the cost of accessibility barriers. And this could take this could be in a number of forms. We could have a toolkit of measures to address the cost of accessibility. Guido Gibbels, for example, refers to a toolkit of different funding mechanisms. For example, we could have a universal service model where industry players comply with certain obligations and they support the cost of delivering these obligations. We could have a trust model where there's a high-profile case, for example, a high-profile cause, sorry, and which attracts major donors. Specific taxation, for example, a levy on the users of a particular service, or general taxation. And also, another way to fund, as part of this toolkit of measures, could be some of the cost to be supported by market players. And Guido Gibbels draws parallels with the cost of health and safety, the cost of safety features in a product. Nobody thinks twice about making a product safe. That is just part of doing business. In the same way, we could think of accessibility and the cost of making a product accessible as just part of doing business. The declaration recognizes the need for enhanced public and private funding, and it states that such funding is urgently needed to ensure that people with cognitive disabilities can access information and technology. And that would have wider benefits, as stated in the declaration. It would create new markets and employment opportunities, decrease dependencies on public service, reduce healthcare costs, and improve independence, productivity, and the quality of life for people with cognitive disabilities. We also need to move away from the medical definition of disability in favor of a social definition. Now, the case studies have shown that a lot of jurisdictions focus on a medical approach to disability, and a lot of the language in the provisions tends to be paternalistic, referring to people with disabilities as disadvantaged or vulnerable members of society. And some jurisdictions rely on the medical approach. The CRPD reaffirms the move away from the medical model and refers to the social barriers encountered by people with disabilities when accessing ICTs. So the focus is on tackling social barriers. And even more important, respect for difference and acceptance of people with disabilities as part of human diversity and humanity. And a similar focus on dismantling social barriers is also present in the declaration, on a focus on dismantling social barriers and on proactive measures to tackle these barriers. We need to move away from the hierarchy of protection for people with disabilities in favor of a rights-based approach, because information and communication technologies play an important role in everyday life for everyone. And the case studies have shown that legislative provisions tend to favor sensory disabilities at the disadvantage of other disabilities which tend to be overlooked. Now, this is maybe due to a lack of understanding, or it could be due to a lack of understanding by policymakers, by market players, for example. And another battle is to tackle the attitudinal barriers encountered by people with cognitive disabilities within society. The UN Convention, the CRPD, talks about the full and equal enjoyment of human rights and fundamental freedoms by all people with disabilities, and respect for the inherent dignity and individual autonomy of all people with disability. And the provision on access to information, with regards to information intended to the general public, it needs to be provided in accessible format, appropriate to different kinds of disability, in a timely manner and without additional costs. So all disabilities are included. Now, the declaration plays a very important role in increasing the visibility of the need for accessible provisions for people with cognitive disabilities. And it provides a very important benchmark in this regard. We also need an increased reliance on active regulatory intervention to eliminate accessibility barriers. So we need active regulatory intervention to protect citizenship interests, including equal access to ICTs. Because the case studies have revealed that a lot of provisions rely on voluntary efforts from the industry, and they give an excessive amount of discretion to industry players for example, when it comes to accessibilities, they could have universal design or they could have retrofit measures. And the language is very much, market players should endeavor to, for example. So there's a lot of discretion provided to market players. But the CRPD calls on state parties to take appropriate measures to ensure the equal access to information for people with disability. The scope, however, is limited to state parties, and private service providers are merely encouraged to enable accessibility. The declaration highlights the significance of accessible solutions for people with cognitive disabilities. 28 million US citizens have cognitive disabilities, and the declaration highlights that the vast majority of people with cognitive disabilities have limited or no access to comprehensible information and usable communication technologies. So it highlights how important this issue is, and how important is that measures are put in place to address this. We need to move away from retrofit measures in favor of universal design and incorporate accessibility at the outset. Now, the case studies have revealed that there's insufficient emphasis on universal design, and regulatory frameworks confer industry players with a significant degree of flexibility. And accessibility solutions are often adopted as an afterthought, reliant on retrofit measures. In the UN Convention, universal design is the preferred approach, and add-on solutions are only if absolutely necessary. And state parties have an obligation to promote universal design. The need for universal design is recognized in the Declaration as well, which calls for people with cognitive disabilities to have access to commercially available devices and software that incorporate principles of universal design, and that is flexibility and ease of use for everyone. We need an increased level of involvement by people with disabilities and representative organizations in policy making. Now, as the case studies have shown, there are limited opportunities for people with disabilities and representative organizations to influence and be involved in policy making. And regulators tend to give more weight to the voice of the industry rather than citizenship voices or the voices of organizations representing people with disabilities, even when industry voices put forward mere opinion. For example, cost is often an argument put forward to explain why not more is done to ensure accessibility. But that is not very often, or not always, backed up with precise data. It's often based on mere opinion. Yet policymakers tend to give a lot of weight to mere opinion if it comes from an industry background. The CRPD requires state parties as a general obligation to closely consult and actively involve people with disabilities through their representative organizations. And the Declaration provides an important common point of reference in advocacy for people with cognitive disabilities and representative organizations. And I was really glad to see that some of the initial signatories, some of the initial organizations that have endorsed the Declaration are organizations representing people with cognitive disabilities. And we also need an increased level of international cooperation for eliminating accessibility barriers. And that's particularly important for television-like services transmitted via the internet and web accessibility, especially because of the jurisdictional and enforceability challenges associated. And the need for international cooperation is illustrated in the CRPD, but also the Declaration. The Declaration tackles a problem that is not exclusively common to the United States, and therefore it can play a very important role in the wider world context as a benchmark. So in conclusion, where do we go from here? So I talked about the need for a regulatory framework promoting citizenship values and based on a framework of principles based on equality and dignity, protected through active regulatory intervention, and protecting the rights of all people with disabilities. But unfortunately, at the moment, there are significant gaps in the level of protection. There are significant barriers to access. And I'll quote from Guido Giebels. He said that we keep on going round in circles and highlighting issues rather than having a clear and broadly agreed roadmap that this is where we are now and this is where we want to get to. I think that the declaration presented today provides that very clear roadmap that's needed. And I think that this calls for efforts from everyone, from all key stakeholders, from policymakers, regulators, industry organizations representing persons with disabilities, and the civil society in general. Now, the Declaration promotes an inclusive society, a society which respects the dignity of everyone. And today, the day when the Declaration was presented to the world, is a very important day. But I think that more important than today is tomorrow, and the day after tomorrow, and the days after that, when the objectives put forward in the Declaration are put in practice. And we can all play a part in this. Thank you.